Welcome to PE Pathways, our podcast series where experienced dealmakers share their thoughts on current private equity and M&A trends and developments. Today, we are going to discuss employee retention tax credits. I'm your host, Thao. I'm a partner in the private equity group at my firm, and I'm joined by two of my fellow colleagues in the private equity group, Jeremy Levy and Thomas Gray. Thomas is also a member of our firm's tax practice, and he's here to demystify everything about ERCs. Thomas and Jeremy, it's great to see you guys. Anything you want to say for the crowd?
Hi, Thao. Thanks for having us here. This is Tom Gray. I'm a tax partner in our New York office.
Hi, Thao. Thanks for having us as well. And this is Jeremy Levy. I'm a corporate M&A partner in our Berwyn office. And what could be more fun than talking about employee retention tax credits? Excited to be here.
Also known as the letters ERTC, which is very popular among deal lawyers, and it's thrown around so often. So Thomas, you being the tax guru that we have here, can you tell us what ERC or employee retention tax credits really are and when they were created?
Sure. So the ERC stands for Employee Retention Credit. It's a credit with respect to an employer's portion of the Social Security tax and Medicare tax the employer pays with respect to wages. So the ERC was first created back in March of 2020 under the Coronavirus Aid, Relief, and Economic Security Act. Back in those dark days when the economy was shutting down, folks were not able to get to their jobs, governments were issuing orders, mandates to shut businesses down, and it looked like there was a possibility of going into not only a recession, but even a deeper, darker, potentially depression. And Congress decided, along with a variety of other provisions, to supply employers with the means, the cash, to fund their employee payrolls.
So Thomas, just to expand on that, was this something that can only be claimed by employers, or could I have claimed something like this as well?
Sure. So generally, it's just employers that are engaged in a trade or business or tax-exempt organizations, individuals, folks who are running their own consulting business or may have had an individual with certain employees, they couldn't claim it. It had to be employers with this trade or business or tax-exempt organizations. So in order to claim that ERC, there needed to be a specific government order shutdown, or they had to reduce their gross receipts by a large percentage. And that was an objective standard. You would compare your gross income versus a previous period's gross income. And if you reduce that gross income by enough, you could get this credit. You could qualify for this credit.
So now we're in 2025. It's been 5 years since the beginning of the pandemic, thankfully. But why are we really talking about this now? I mean, it seems to be one of those topics that's been done and over with.
So the reason we're talking about it now, so long after the passage, is those claims are still potentially being processed because of the statute of limitations. For at least 2021, those persons who still want to claim an ERTC still have the capabilities of amending prior returns. The statute of limitations, for the most part, for 2020 have passed. With those statute of limitations, the IRS could not go back and say that there was any type of issues. They couldn't open an audit. For 2021, those statute of limitations generally end next year it should be April of 2025 for the first 2 quarters of 2021 tax returns. And these are payroll tax returns. They're not income tax returns, they're payroll tax returns. For the third quarter of 2021, the statute of limitations was extended to 5 years. So you have the potential for the IRS to come back up till 2027 and open an audit with respect to ERCs. Now, that's your typical statute of limitations. The limitations, they can come out under a different procedure where, let's just say for the 2020 tax period, you didn't get the refund till this year. And let's say, so it's the beginning of 2025. From that period, the IRS has 2 years to make a claim that you received an erroneous refund. So even though the technical statute of limitations for that 2020 tax period have ended, because you didn't receive that refund, the IRS has 2 years from the date you receive the refund, so it can extend it. And there's a lot of refunds that have not been processed yet.
So just to clarify something, because we use the term statute of limitations quite often. So there's one statute of limitation where the IRS can come back and say, you took an improper refund. But is there another statute of limitation as to when I, as the employer, could have claimed that refund from this legislation?
Yeah. So generally, you have 3 years from the due date of the tax return. So for a payroll tax return, let's say it's June 30th of 2020, the payroll for that payroll tax period, the statute of limitations starts running April 15th of 2021, and that's 3 years. So if you went to tax period of June 30th, 2021, the same thing would happen. That tax period starts running, the statute of limitations is the next year, 2022, April 15th. So you have 3 years from that day to amend your tax return. You have 3 years for the IRS to come in and start looking at it.
So this is why 5 years later from 2020, we're still talking about it.
Exactly.
So that makes an interesting dilemma for a deal lawyer. So Jeremy, I'm going to turn this to you and say, what are you thinking about in this situation, whether you're a buyer or a seller, and you're thinking about a target company, that one, should they have amended their tax return to get the credit? Or if they did amend the tax return and got a credit, and now you're like thinking, did they do it properly? So where does that put us in the deal world?
Part of the reason why we care, those of you listening to the podcast have noticed we've spent a lot of time talking about statutes of limitations. The reason we're talking about that is because many of these claims were fraudulent, poorly supported, and either contested or subject to contest from the IRS. On the buy side of deals, we've been looking for years at target companies that previously claimed these credits. And we found during the course of diligence, to the extent we can diligence these topics, we'll come back to that in a minute, that in many cases, the claims were not substantiated. In fact, Thomas will remember the IRS has a particular hatred for ERCs. There were a number of shops that were springing up out of nowhere. Companies were getting mailers suggesting that, did you know you might be entitled to receive this credit? And there were these shops that were providing documentation and helping companies file for these credits and taking as a fee a portion of the amount claimed. So in many cases, there were these fraudulent actors who were filing for these claims on behalf of companies, even though the company didn't necessarily realize that they were eligible for or think that they were eligible for any of these claims. So almost from the outset, the IRS identified these as problematic. And Thomas will tell us a little bit about the sort of moratoriums that were put into place. Actually, why don't you do that now? Tell us a little bit more about the history of the problems that have given rise to all this conversation about statutes of limitations.
In the beginning, when this act was passed, there were no forms specifically designed to claim this refund. So folks just filed stuff willy-nilly. There's a 941 employer quarterly return that is supposed to be filed. Some people amended those returns before the actual returns were put in place to be able to claim the credit. The IRS was shut down for a number of months in 2020, just like every other organization. And then they didn't even begin processing the claims until 2021 when their computer software was updated to handle it. And then, as you noted, there was a lot of promoters out there just pushing these claims. We had clients who received claim refunds and claimed they never supported anything and then got a bill from a promoter. We had a client that was looking at providing loans based on anticipated ERC claims and asked us to review the ERC claims that the proponent borrowers had made. We went through those, and probably 19 out of 20 were things we could not substantiate that they could survive an audit by the IRS. So there was a lot of questionable practices. Folks were claiming the credits because they put hand sanitizer. They were affected. You were supposed to either have that income reduction or a government shutdown. If your supplier was shut down and you just were inconvenienced, you're not able to claim that unless you met the gross income test. A lot of folks, because they were inconvenienced, business was difficult, they made the claim. So because of this, the promoters, the false claims, the IRS listed the promotion of these as one of their dirty dozen tax scams that was going on. And by September of 2023, the IRS stopped processing any new claims. They have a moratorium on it. So they were still processing older claims, but they stopped processing new claims because they were just so inundated. And if they began to have a lot of pressure to get these payments out because a lot of employers were relying on them, you definitely needed them. But because there were so many difficulties with processing the claims, a lot of things slipped through the cracks. And the Treasury Inspector General of the Tax Administration looked into 1.9 million claims that were filed and found that was about 185,000 that should have been tagged for audits that were not tagged, and went back to the IRS and said, these are funds that have been paid out with respect to claims that we should have looked closer at. And the IRS has that on their list of things to do. So just think about those numbers. That's 185,000 audits that are potentially there. So if you have a target company that has a big ERTC claim, you should expect that there's a good possibility it's going to be audited. And that audit may not come for a number of years.
So against that backdrop, we go back to Thao's original question, which is, what are we doing about this in deals? So during the course of, call it 2021 to 2023 or so, on the buy side, we're aware of this fraud. We are aware of the relative distaste for ERCs on the part of the IRS. And so as a buyer, our clients would ask as a diligence matter, did you, target company, claim an ERC? And if the answer is yes, the buyer would simply say, we don't believe you're entitled to it, right? We just are going to assume that either you claimed it incorrectly, or at least the IRS is going to come audit you about it. And that is just something that the buyer does not want to be involved in. And so what we were doing during that period of time was establishing escrows for any claims that had already been processed, where the target company had received the funds. Those funds would be taken out of the target company's bank account or what have you, and placed into escrow. And it would sit until the expiration of the statute of limitations that applied to the particular credit. Thomas went into the credits for the 2020 tax year had statute of limitations that ran for a certain period of time, and then the Q1, Q2, and Q3, Q4 of 2021 had a different statute of limitations, which is part of the problem with the law in the first place. So we were just putting in purchase agreements that any amounts that had been received in respect of ERCs would go into escrow, and it would sit there until the statute of limitations passed. And that was nice and clean and easy. Unfortunately, it's now 2025, and some of the statute of limitations have passed, and other statutes of limitations for other quarters are about to pass or close to passing. But we heard Thomas say earlier that depending on when the refund might be processed, the statute of limitations for making the claim may have passed, but the statute of limitations for refunding any amounts that were improperly received may not have passed. And so now we are in a world where we have buyers who still don't want this to be their risk, but we have sellers saying, how are you putting this ERC amount that I received in escrow when the statute of limitations has already passed? And that is the challenge that we're facing these days when we're trying to address these in purchase agreements.
Jeremy, you mentioned something interesting because I think a lot of the commentary you were just making now was a very simple transaction where seller sells company 100% to the buyer. And I can tell you that in secondary transactions, which it seems to be the buzzword, the flavor of the month in the private equity world right now, which at the end of the day is just a mini M&A transaction where you give partial liquidity to existing holders in a selling company. And this is a concern that is happening as well, that you are having savvy institutional buyers who are putting money in with a private equity firm to give liquidity, partial liquidity to their LPs. And they're diligencing these portfolio companies that have obtained ERCs, and they're approaching it in a very similar way through a full M&A transaction. And it's basically a very simple rule, or keep it simple, stupid, follow the money, right? So you seller or whoever got to get out with cash, you benefited from this ERC. And so if it is wrong for whatever reason, then the buyer should be able to, that is, go back and reclaim some of this cash. The other distinction I also want to make is that we'd also been talking a lot about bad actors in the dirty dozen. I think buyers are also taking this approach, even if there's nothing nefarious, where you could have a bona fide, legit payroll provider who is trying to be helpful to a portfolio company and saying, hey, here's these ERCs. we're your payroll provider. We know what's going on and we can file for you. And this is cash that will help your business. And so I think in that scenario, even though it's not nefarious, I think a buyer's approach is like it's strict liability. If you got the credit, no matter how, you should stand behind it as a seller. Would you agree with that, Jeremy?
Absolutely. I think from a buyer's perspective, this is just a risk that buyers are not willing to take. And they're not willing to take it regardless of whether or not the statute of limitations for the applicable quarter has passed. I don't see any buyers who are actually paying sellers for the value of ERCs that they have previously received, or for any ERCs that have not yet been processed and are expected to be received. So that's point one. No one is paying value for this. No one's paying a multiple on that cash, and no one is paying for that cash. As far as the risk is concerned, if credits are still to come, right, there's still an outstanding claim, but it has not been processed by the IRS. What we're most frequently seeing is some sort of a springing escrow, where if the money does come in at some point in the future, it will be diverted directly into an escrow. And once whatever applicable statute of limitations that then exist expires, then and only then will the buyer pay those amounts over to the seller so that the seller can get the value of those. But that's basically the level of risk that buyers are willing to take on it. And with respect to the ERCs that have already been received, even if the statute of limitations has run, most buyers are asking for no longer a release time from escrow tied to statute of limitations, because that has run already, but instead they're asking for just a fixed period of time. Call it 2 more years, call it 3 more years. And part of the reason for that is that there is, and there has been, outstanding legislation that is intended, or at least been intended, to extend the statute of limitations, right, Thomas?
Yeah, so there has been proposals, one made it through the House, but stalled in the Senate, that would have extended the statute of limitations by a couple of years. Who knows if it's going to pass in the future? You know, you can expect that in 2025, there's going to be some tax legislation that'll pass, at least to try and extend the 2017 Tax Act that's expiring. And maybe this will come up in that tax legislation.
So if there's a moral to this story, ERCs generally are bad and the IRS hates them. And if they're involved in your deal and you are a buyer, you want to run far away from them and put as much protection as you can in the agreement. And you can't rely on the then applicable statute of limitations, which Congress still may extend, or there is already the extended 2-year period once the refund comes in, even if the statute of limitations for the claim has passed. So this is something that I think we're going to continue to be hearing about and dealing with for the next several years.
Well, this was a very interesting topic, and I think also a very timely topic, given where a number of our deals are with our private equity clients and our portfolio companies, to the extent that we're representing targets. Really appreciate the time, Jeremy and Thomas. It's always great catching up with you guys to cover some hot topics like this. Thank you for listening to our podcast. Please keep an eye out for additional episodes of PE Pathways, where we bring experienced deal makers together to share their thoughts on current private equity and M&A trends.
Copyright Troutman Pepperlock, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman does not make any representations or warranties, expressed or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepperlock. If you have any questions, please contact us at troutman.com.